Okay, this will be some four-voice practice at 200 words a minute. We have our attorneys. We have Mr. Morris for the plaintiff and Mr. James for defense. It has a lot of colloquy in it, but we'll identify.
I'm the attorney for the plaintiff, Mr. Morris.
I am the witness.
I'm the court.
I am defense attorney, Mr. James.
I'm starting at the front.
I'm starting at the very beginning. And 15s, please.
And it's the court for the record. Call action number G45077, People versus Carl Edward Williams.
I'm appearing on behalf of the defendant. I move to exclude witnesses at this time.
All persons who are summoned to testify or all persons who are going to testify, whether under summons or not, are ordered to remain outside the courtroom until called by the bailiff. The reason you're excluded is so you will only testify from your own memory. So you won't be testifying from what you heard some other witnesses testify to. Therefore, you're instructed not to discuss the case with anyone else except the attorneys until the hearing is concluded. The district attorney will be responsible for assuring the court that the witnesses are not present in the courtroom. People are ready to proceed?
People are ready to proceed, Your Honor.
Call your first witness.
Thank you, Your Honor. I would be calling John Boyd at this time. He's out of order because he will not be available tomorrow. I don't believe counsel has any objection.
No objection.
Mr. Boyd, would you please state your full name and spell your last name for the court reporter?
My name is John Charles Boyd, B-O-Y-D.
Would you tell us what your occupation is?
Yes, I'm employed as a criminalist by the California Department of Justice at the North Coast Criminalistic Laboratory College of the Redwoods.
Thank you, Mr. Boyd. Is one of your duties or functions with the lab the analysis of items that are suspected to be narcotics?
Yes, sir, it is.
For the purpose of the prelim, do we have a stipulation as to the qualifications?
I don't know what he's going to be testifying to, Your Honor. I've requested all discovery through the informal discovery process that has been set up with the district attorney's office and my office. I haven't received any indication at all that any evidence was ever presented to the CR lab.
For proof, Mr. Morris?
Your Honor, I think it can be assumed it was indicated from the discovery that the items would be tested. I don't have a copy of any report from the lab as to the results. I was advised by phone as to what those results were, however.
Well, Your Honor, I can't assume anything because on a lot of drug cases, I think, as Your Honor knows, quite frequently Valtox testing is done by Frank Jagger. Frankly, that's what I thought was going to happen. I didn't have any test results. I thought the officer would be coming in to testify concerning his testing of the substance.
I assume there's no way we can get any stipulation as to the qualifications?
I'll also be objecting to his testimony based on lack of discovery.
I don't know what it is at this time he's going to testify to.
Your Honor, he will be testifying to the fact that he tested various items, pills and liquids. He determined those items to be various types of controlled substances, narcotics.
Are there no indications in any discovery provided to defense counsel that suspected items were seized?
Oh, yes, it's indicated. The items were seized and were suspected to be various types of drugs and were identified as such on their labels. There is no report from the lab technician in the discovery, and I myself discovered today that I did not have a report from the lab technician either. If counsel wants an opportunity to look at the witness's report, I believe that could be done. I don't think there is any prejudice to them, given it was obvious that the items would be tested. It was certainly expected the test would indicate they were the items described.
Are there any indications in any of the police reports that would indicate that certain items were sent for testing?
I'm not sure that it specifically says that they were sent for testing.
In viewing any of the discovery, Mr. James, could you indicate whether you ever saw any indication of items sent for testing?
No, Your Honor, I don't recall seeing that. I do have reports indicating suspected controlled substances were seized. The police reports indicate apparently that the druggist could identify those items, and I frankly expected that particular person to be the one that identified the item that were seized pursuant to the various searches involved here. I did not know that items had been sent to any Department of Justice lab for testing. If they were going to try to establish the exact nature of the items, I frankly expected Frank Jagger to do it because that's been the common practice for preliminary hearings in drug cases.
Your Honor, there's certainly no prejudice to the defendant.
I understand there's no prejudice to the defendant. Is there any report available at this time to provide defense counsel before we proceed?
The witness does have a copy of his report.
Would you allow defense counsel to look at that?
Certainly.
I also will, for the record, object at this time. There was no formal discovery motion made.
That was my next comment.
All right, the reason there wasn't, there's a form provided by my office for discovery that is commonly used. It is used in every one of my cases. It's an informal discovery procedure. I rely upon that on good informal assurances by the district attorney's office that I'm provided my discovery. I think that is good enough. If it's not, then this court is going to be tremendously overburdened by discovery motions filed by me and other contract defense counsel, because if we can't rely upon the formal, informal discovery procedure of the district attorney's office.
It cuts both ways, Mr. James. If you're going to use an informal proceeding, then when something isn't given because the DA thought this isn't normally given, I don't know, you wanted to use this thing or whatever, then they are also relying on the informality of it. You know, there were items seized. You anticipated someone would be testifying about that testing, but your complaint is that it doesn't happen to be the one that is here today. It would appear that by examining a document, you can tell the court whether or not you need more time to prepare.
I'm perfectly willing to examine the document.
And I don't think with formal discovery, the appropriate sanction would be exclusion. I don't think the court can do that. I certainly don't want to disrupt any workable routine between defense counsel and the DA's office. Let's give you the document. Let you look at it and see if we can proceed from there, okay?
Fine.
Apparently the document is there, is that correct?
Yes, it's a copy of the laboratory portion.
Is there more than one test?
That particular form is one summation containing a set of items, and the note for the analysis is on the reverse portion of the page.
Does that cover everything, that one form?
No, there's also a second envelope that had a second, there were pills contained in the second item that is on this form.
Your Honor, could arrangements be made to make Xerox copies of these reports for our examination? There are 3 of these.
Your Honor, perhaps we can have the bailiff make copies of those. There's going to be a recess or something this afternoon. Counsel could look that over. I could put on other witnesses in the meantime.
That's fine. I want to see this and look at it before he starts testifying. But if he wants to call another witness in the meantime, give me an opportunity to review it before he's called upon.
Step down, Mr. Boyd. Remain outside the courtroom. Who will your next witness be?
Victoria Barrera.
As soon as that witness is available, bailiff, get somebody to make copies of those, 3 each, 4 each.
Your Honor, before this particular witness is sworn in or further called to testify, I would object to her being called and to her testimony. Carl Williams, a defendant in this action, is the husband of the proposed witness. My understanding in talking to Mr. Williams is that his wife intends to invoke the spouse witness privilege and not testify at this proceeding because he is a party to it. I further believe, based on my analysis of the evidence provided to me in discovery, that this witness may well incriminate herself by testifying, and therefore she should be advised by the court and by counsel representing her regarding whether she should testify at all. I've not talked with her about her testimony. I have talked with her husband.
Is this witness the wife of Carl Edward Williams?
Yes, she was married on July 19 by Your Honor in Arcata, I believe.
Your Honor, if Your Honor can indicate to me that that occurred, I will take it on his word for it. I did check approximately a month or 2 ago. At that time, there were no records on file indicating any marriage. I anticipated, however, that that might be the case today. And as long as I have some either documentation or something to assure me that in fact there has been a valid marriage, then I would have to agree that there is a valid marital privilege.
The lady is familiar to me, but I have done over 3,000 of them.
I was pregnant at the time. I was going through labor. You told me not to worry because you could deliver the baby if necessary because you had delivered one already when you were a police officer.
Your Honor, I have documentation of the marriage.
I think I performed the ceremony. Are you intending on invoking the wife-husband privilege here?
Uh-huh.
What do we do now? Bifurcate? Is there any way we can edit?
No, I don't believe so. I'll have to think about that. I won't call her at this point in time. I'm not sure there is anything she'll be testifying to other than testimony as to Defendant Williams.
I take it that this witness is in no way the victim in the matter?
No, she is not.
Ms. Williams, apparently Mrs. Williams, you will remain outside the courtroom. You're still subject to subpoena. This hearing will probably go through today and into tomorrow. You're to remain available as a witness until such time as you receive word from my bailiff that you're no longer needed.
From who?
Your Honor, I would have no objection to her leaving the courthouse today, going about her duties or whatever. I'm assuming the prelim is not going to be completed today. I have enough witnesses for today as long as she would be available for tomorrow.
You need not return to the courtroom. You're to be available upon 30 minutes notice by phone. So you are to simply remain in the vicinity of the phone until the matter is concluded. I assume you have a number you can give to the bailiff. He will come outside in the hall and get it. You may be excused. Remain available until this hearing is concluded. Your next witness.
Sergeant Hansel. Sergeant Hansel, would you please state your name for the record?
William F. Honsal, Honsal.
Tell us what your occupation is.
I'm a detective sergeant with the Eureka Police Department,
How long have you been employed as a peace officer?
13 years.
Thank you. And directing your attention to the date of June 28th of this year, did you have occasion at that time to, I assume, be working for a police department?
Yes, I was.
What was your specific assignment at that time?
I'm working all major crimes that occur. It can vary from armed robberies to narcotics violations to sex crimes.
Thank you. And directing your attention to the date of June 28th, did you have occasion to receive a phone call from an individual named Shane Keeley?
Yes, I did.
At that time, did you know who Shane Keeley was?
Yes, I did.
Had you had prior contact with Shane Keeley?
Yes, I had.
What was his relationship to the police department at that time?
He was an informant.
Had you worked with him on previous cases?
No, I had talked to him on several occasions about crimes that had occurred here and in other counties, and spoke to him briefly about criminal cases in which he was involved as a defendant.
In that phone call on the 28th, did Shane Keeley indicate that he had some information that you might be interested in?
Yes, he did.
Did you thereafter meet with him that day?
No, I spoke to him on the phone.
Did he give you some information concerning a robbery that had occurred at Buxton's Pharmacy on the 26th of June?
Yes, he did.
Your Honor, I object to that question and to the answer as being hearsay.
Your Honor, it was not offered for the truth purposes at this time, simply for probable cause for the later arrest of the defendant.
Objection overruled. It will be permitted for that purpose only.
Thank you. Could you indicate for us, could you answer that question?
Would you repeat it, please?
Yes. Did Shane Keeley give you some information at that time concerning a robbery that occurred at Buxton's Pharmacy on the 26th of that month?
Yes, he did.
What was the information he gave you?
He told me that he had met Carl Williams the previous day, Sunday, and that Carl had admitted to him he had involvement in the Buxton's Pharmacy drug robbery. He had some of the drugs.
Your Honor, I presume there's a continuing hearsay objection.
Yes.
Thank you.
Now, did Mr. Keeley give you some specific information concerning statements that Carl Williams had made to him regarding that robbery?
Yes, he did.
Your Honor, may I ask a question at this time, not of the witness, but of the court? I see no reason why there should be testimony at this time concerning probable cause to arrest a defendant unless the arrest is an issue before us at this time. Seems like we're putting the cart before the horse.
Your Honor, the arrest, I'm assuming, will be an issue. There's going to be testimony concerning the arrest and evidence obtained subsequently. Is counsel indicating to me that they are not going to contest the probable cause for arrest? Maybe that's not an issue. As far as I'm concerned, it's up to me to establish that probable cause.
Just about everything can come up in a prelim that can be objected to. I don't assume you're willing to stipulate to that, Mr. James.
No, as far as I'm concerned, the arrest was unlawful.
Okay, it would appear it would be relevant then, if that's to be the basis. Proceed.
So the reason for this testimony is because the DA is trying to establish that the arrest was lawful, the arrest of Mr. Williams?
He would have a burden of doing so. Otherwise, I assume you're going to ask to have the matter dismissed based on unlawful arrest.
There hasn't been any evidence produced yet, a product of arrest. I haven't had a chance to object to its admission.
At such time as it comes about, I'm sure you will. I think we'll have to follow the normal course of events. I'm not allowing the evidence to come in for any other reason than probable cause to arrest. I assume it may have resulted in some sort of a seizure of some evidence. I make that assumption. Proceed, Mr. Morris.
Thank you.
Yes, Shane told me that Carl had told him that he had done the heist. Quote, I had done the heist. Man, I've got everything in sight.
Did Mr. Keeley indicate to you on what date it was that Carl Williams made that statement to him?
Yes, that was the previous day, which would have been a Sunday. This would have been the first day that Shane had been out of jail. He had been released from county jail early Sunday morning, and later on that afternoon, Shane told me that he had met Carl Williams and another couple at the county fair.
At that time, did you have information concerning the robbery at Buxton's and when it occurred?
Yes, I did.
What was the date it occurred?
Your Honor, this is hearsay also. Is the reason for this testimony to establish probable cause for an arrest also?
Yes, coming in for the same purpose, Your Honor, so we can establish the officer's state of mind, establish the information the officer had at the time he made his arrest.
Proceed.
Yes, the robbery occurred on June 26th at, I believe, just after 10 o'clock in the morning.
Was that a Saturday?
That was a Saturday. I happened to have been on the telephone talking to Officer Ron Waters at the police department when the armed robbery was reported to the police department.
Thank you. Now, do you recall being contacted by Shane Keeley again on July 1st?
It was on a Thursday. Yes, I did.
And did Shane Keeley provide you with some additional information concerning witnessing drugs in the possession of Mr. Williams?
Yeah, he did.
Again, Your Honor, same objection.
Allow it for the same purpose. There will be a continuing objection on the record.
Thank you.
If it's offered for any other purpose, then I would expect you to object at that time. I assume, Mr. Morris, all we're doing now is laying the foundation for the probable cause.
That's correct.
All the relevance of this evidence as far as she's concerned is to establish probable cause for arresting Mr. Williams?
That's correct.
That would be my understanding of his representation to the court.
I keep forgetting what the question was.
I recall the question.
Okay.
Shane did provide me with information that he had been to Carl Williams' house and had seen specific drugs, which he was familiar with. He described those drugs to me.
Did the type of drugs that he observed match the type of drugs that had been taken in the robbery at Buxton's?
Yes.
Did you arrange with Shane Keeley at that point in time to work with you or to attempt to try and get in touch with Carl for the purposes of buying some of his narcotics?
Yes.
Do you know whether or not, excuse me, strike that. Did either you or Shane Keeley make any efforts to locate Carl Williams on that day?
Yes, we attempted to make contact with him that evening.
And were you successful in locating him that evening?
No, he was gone from his home.
Directing your attention to the date of July 2, did you have occasion to at some time on that day see Carl Williams?
Yes, I did.
Where did you see him?
I had parked on C Street beside the fire department in which we're now housed. I got out of the car. Carl Williams was walking towards us, walking down the sidewalk from 6th Street to 5th Street on the west sidewalk of C Street.
Did you see him enter any buildings or structures?
Yes, he entered the basement parking area of the Seafarer Motel.
Once you were inside the police department building, did you receive a phone call from Shane Keeley that day?
Yes, later on that early afternoon.
Did Shane Keeley at that time give you some information again concerning Carl Williams?
Yes, he did.
What information did he give you at that time?
He said that Carl was staying at the Seafarer in room 211.
Did you then arrange with Shane Keeley to work for you in making an undercover narcotics buy from Carl Williams?
Yes.
Did you later that day on the 2nd meet with Shane Keeley at the Thunderbird Motel?
Yes.
At that time, did you yourself conduct some type of search of the person of Shane Keeley?
Yes, I did.
What type of search was that?
Standard procedure in these types of buys.
All right, this will be some more 200 practice, 5 minutes, and then we will go up to 210. And we have Mr. Mayo for the people, Mr. Shaver for defense. Let's identify.
I am the, the attorney for the plaintiff, Mr. Mayo.
I am the witness.
I am the court.
I am Mr. Shaver for defense.
It's the court for the record. Good morning, ladies and gentlemen. We are back on the record. All parties are present. Our witness is still on the stand under oath, and you were still on direct, Mr. Mayo.
Thank you, Your Honor. Detective Moreno, when we finished yesterday, you had been looking at exhibits 59 and 61. Have you had an opportunity to determine if you recognize those exhibits or not?
Yes.
Can you look at those exhibits for us and tell us what they represent?
Okay, photograph item 59. This is a picture of Sabrina's left torso area, and it's focusing on this wound here, which is a gunshot wound.
And could you describe where that is in the picture?
It's on the left upper torso of the body.
Thank you. How about 61?
Photograph 61, it's a photograph of the same area. It's just that the area is cleaned up and it's given a focusing on the wound on the left side torso of Sabrina's body.
Thank you. And can you tell us if you recognize exhibit 62?
Yes, I recognize the exhibit.
What does that represent?
For which item?
Pardon?
Which item?
I'm sorry. Do you have a picture of 62?
This is photograph item 62, and 62 is, it's showing Sabrina's left side torso area And the photograph is emphasizing the bullet jacket to the wound.
Thank you. Can you tell us if you recognize Exhibit 64?
64?
I'm sorry, 63.
Photograph 63 it's a photograph of focusing and emphasizing on the bullet jacket that was removed from the left torso area of Sabrina's body.
And 64, please?
64?
Yeah.
Photograph 64, it's a picture showing the sole of Sabrina's left foot, and you will see the wound.
And then do you have a 65? Can you tell us if you recognize that? And if you do, can you tell us what it represents?
Photograph 65 is a photograph of Sabrina's left foot. It's just the area of the injury. The sole has been cleaned up.
Thank you. And then can you look at Exhibit 66 and tell us if you recognize that?
Photograph item 66 is Sabrina's left foot, but it's emphasizing on the top of the foot and focusing on the injury, the wound.
And I believe you have one more exhibit.
This is photograph item 67, and this photograph is focusing on a bullet fragment.
Is that the bullet fragment that was removed from her brain?
This bullet fragment was removed from Sabrina's brain.
Okay, now thank you. During the course of this autopsy, did you observe Dr. Lawrence remove the bullets?
Yes.
And when he removed the bullets, what did you do?
What did I do?
Yes.
I was standing right by him, and then I would ask him questions.
Would he give you the bullets or did he keep them?
Well, I believe first he removed the bullets, cleaned them up, and I think they were photographed, and then they were packaged by his assistant, and then they were placed into a bag, a big bag, brown bag.
Did you mark those fragments so you knew where they had been removed from?
Yes, I initialed the container.
If I show you those containers, will you be able to recognize them?
Yes.
Showing you 3 exhibits that have been marked Peoples 87, 88, and 89. I'm going to ask you to look at Exhibit 87 first. Tell us if you recognize that, how you recognize it, and tell us what it is, please.
Okay, evidence item 87, I recognize it. For one thing, the envelope, it's my writing. I marked it Sabrina Danke. I labeled it NM4, and then I described this bullet fragment was taken from the brain of Sabrina Danke and stored in a plastic container. And then I dated it and I put my name on it.
Can you open that up for us? Before I have you recognize that, could I have that exhibit? I'll have it marked.
May I approach, Your Honor?
Yes.
87A marked for identification. I'm going to show you an exhibit marked for identification and ask if you recognize what that is.
I recognize it.
What do you recognize that to be?
This is a plastic container. It's containing a bullet fragment from the brain from Sabrina Danke.
And how do you recognize that?
I don't have my initials on this item.
Is there a way you recognize that? Did you see the writing from it? Is it dated? Any other way that you recognize that particular writing?
Because of the envelope when it was handed.
So the item you were handed from the envelope contained that exhibit.
Right, correct.
Does that exhibit have a name on it?
As an item number or?
Does it have any kind of information on it?
Yes, it has the victim's name.
And what name is that?
Sabrina Danke.
And did that exhibit item have that same name on it when you placed it in the bag?
Yes,
Is it dated as well?
it is dated March 10th.
Okay, thank you. Can you open that for us? And you say that was a fragment.
It was a metal fragment.
Where was that removed from?
There was a metal fragment removed from Sabrina's brain.
Okay, thank you. Can you put that back for us? And I'll ask you about the next one. Can you look at exhibit number 88 for us, please?
Exhibit 88 is a envelope. It has Sabrina Danke's name on it. I labeled it NM6, and I've described it as a bullet jacket removed from the left torso with the date of March 10th, and my name and ID number.
Okay, thank you. Will you open that up for us?
Peoples 88A marked for identification.
I'm going to show you an exhibit marked 88A for identification. Can you tell us what that exhibit represents?
Okay, evidence item 88, it's a plastic container with a bullet jacket removed from the left torso area.
And do you recognize that exhibit?
Yes.
How do you recognize that one?
It was placed into this envelope that I marked.
Did it have that same information you just read on it when you placed it in the envelope?
Yes.
Does it have the date that the bullet was placed in that item?
It has a date of March 10th.
Okay, thank you. Can you look at the next exhibit for us? Let me ask you, before you open it, do you recognize that exhibit?
Yes.
How do you recognize it?
Which exhibit, Mr. Mayo?
I'm sorry, is that Exhibit 89?
This is Exhibit 89, and I recognize it, the envelope. It's my handwriting. I labeled it Sabrina Danke. It's marked with my initials, NM7, and the item is described as a bullet recovered from the brain with the date of March 10th. And then I have my first initial and a last name and my ID number.
Thank you. Can you open that exhibit for us?
Item 89, it's a white plastic container. It's marked.
Let's have that marked first. 89A marked for identification.
Showing you exhibit marked 89A. Do you recognize that?
Yes.
How do you recognize that?
Okay, I recognize it as the one I marked NM7. I recognize it. It has the name Sabrina Danke, the date March 10th. And the item is described as a bullet removed from the location of Sabrina's brain.
Now, can you open that exhibit for us?
It's a bullet.
And I don't know if I asked you or not, on Exhibit 88A, did you have to open up that exhibit?
I'll stipulate that you forgot.
Has that one been opened yet?
No.
Can you open it, please?
Okay, item 88A is a plastic container. It's marked Sabrina Danke. And the item is described as bullet jacket removed from the left torso. And this is the bullet jacket.
Thank you. During the course of this autopsy, did you also observe Dr. Lawrence take any blood from Sabrina Danke?
Yes.
Was the blood that he took placed in any type of a vial?
Yes.
And can you tell us what happened to the vials after he took the blood?
They were marked as evidence.
Who did that?
I marked them as evidence and put them into the evidence property room refrigerator.
I'm going to show you an exhibit.
People's 94 marked for identification.
This is Mark Peoples 94. I want to ask you to look at this. Tell us if you recognize it.
This envelope is labeled evidence item 94, and I recognize it as an evidence item with Sabrina Danke's name. I labeled it NM1, and this envelope contains 2 vials of blood specimen with a plastic container, green top.
And is that all in your handwriting?
Yes.
Does that indicate on the envelope what day you took that item?
March 10th.
Can you open that envelope up for us?
It's 94A marked for identification.
Showing you the envelope marked 94A for identification. Do you recognize that?
Yes.
How do you recognize that?
I recognize them as the blood samples put into a vial and then placed into a container with the green top.
What day was that done?
March 10th.
How many vials does that contain?
It has 2 vials.
Is that also what you marked on the front of your envelope?
Yes.
Now, after you took this blood, where was that blood drawn from, or who was that blood drawn from?
I think it was the body cavity. They drew the blood.
What person?
Dr. Lawrence.
I'm sorry, who was the person they drew the blood from?
I believe it was Dr. Lawrence.
Whose blood is it?
Oh, it is Sabrina Danke's blood.
After you took that blood, what did you do with it?
It was put in a bag.
And then where did you take it?
Not immediately, but once the autopsy was done, I transferred all this evidence to our property room where it was put into a refrigerator.
Thank you. I have no further questions.
Mr. Shaver?
Thank you. I noticed that there was 1 vial of blood taken from the victim, Kevin Danke. Is that correct?
Yes.
And there's 2 from Sabrina Danke?
Yes.
The 1 vial taken from Sabrina Danke was taken from the heart. Is that correct?
Correct.
And you said that those 2 blood samples from Sabrina Danke were taken from her body cavity. Can you be more specific than that?
This area.
The area of the heart?
Yes.
Do you know if they were both taken from the same place or from different places?
I'm not positive if it was from the heart or a specific area, but I knew that it was a general area.
Do you know why 2 samples were taken from Sabrina and only 1 from Kevin?
No, I don't really know the answer to that.
Did you add anything to the blood or take anything away from the blood?
No.
Did anyone else add anything to the blood or take anything away from the blood?
No.
So you don't know whether there was any kind of preservative put in it? Isn't that standard procedure?
If there was any preservative in the vial, I don't know that information.
So the preservative might already be prepackaged in the vial, to your understanding.
If there was any preservative, but I'm not sure.
Fair enough. And you didn't personally take the samples, right?
No.
All right. Now I notice you are wearing a Sacramento t-shirt.
It's Sacramento High Tech Crime Task Force.
That's your current assignment, right?
Yes.
But you were on loan, or are you on loan originally to Sacramento from
San Joaquin County Sheriff's.
San Joaquin County, is that correct?
Yes.
Your training and background as a San Joaquin County Deputy Sheriff?
Yes.
Okay, and you were on loan at the time of this incident to Sacramento,
Yes,
and you still are?
yes,
And you were called to, they kind of repossessed you on that date, correct?
yes.
Why was that?
Manpower shortage on detectives.
Okay, so there was a shortage of people in San Joaquin County on that particular day, is that correct?
I believe that particular date, our homicide unit was fully tasked. They didn't have any available.
When you say our, you are talking about San Joaquin County?
San Joaquin County Sheriff's Department.
All right, now other than you indicated the people present during these autopsies, and I assume that the autopsies were performed on the same day,
Yes.
and were they done in the order that you presented them here today? Doesn't matter, I was just curious.
The first autopsy was Kevin Danke.
Right?
And then after we completed the first autopsy, we started the second autopsy, which was Sabrina Danke.
Which was the order in which they were presented here?
Yes.
Okay, and you said that present at the autopsies were Dr. Lawrence, correct?
Yes.
Who performed the autopsies?
Yes.
And then there was a Wayne Onstad, who is his assistant,
Yes.
and evidence tech, who was taking photographs,
Correct.
taking pictures.
Yes.
Okay, this will be some practice from our 200 take. We have Mr. Stone for the people, Mr. Miller for defense, that's identified.
I am attorney for the people, Mr. Stone.
I am the witness.
I am the court.
I am defense attorney, Mr. Miller. And it starts in colloquy there with the witness in 14th, please.
Okay, for the record. No. You see, we moved out of the house and I haven't talked to her because we had moved and the phone didn't get turned back on in my apartment for a long time until I paid the bill.
Did you move after your mother was arrested?
Yes, I did.
So you haven't talked to your mother about this since, and you just came in here from Oklahoma today or last night,
Last night,
and you're going back just as soon as you can?
yes.
Okay, anything else?
Nothing further, Your Honor.
Is this witness excused?
Yes.
Okay,
I do have one other question, Your Honor, if I may.
okay.
Ms. Castillo, as best as you're aware, you heard your mother talking on the phone about a gun.
Yeah,
How many guns or weapons are in the house that you knew of?
there was none
There was none.
besides the one in the couch.
The one you found in the couch?
Yes,
There were no other guns in the couch that you're aware of?
yes.
Objection, never mind, I'll withdraw that.
Nothing further.
Mr. Miller?
Yes. Do you know for a fact that that gun was in that house, in that couch at the time your mother was talking on the phone?
Do I?
Do you understand?
No.
How do you know that that gun was in the house, in the couch at the time she was talking on the phone?
Assuming a fact's not in evidence,
He just asked it. He framed his question to include that.
No.
I'll ask the court. Can we ask the court reporter to read the question back?
To the extent I misled the witness, I apologize. Ms. Castillo, do you understand that what I'm intending to ask you is, did you know of any other guns in that house, whether they were in the couch or any place else before you found that shotgun in the couch?
Does that mean any other guns?
Any other guns?
No.
okay. Now you may cross-examine counsel. Thank you.
Do you have any idea who put that shotgun in the couch?
No, I only found it.
Okay, do you have, I'm sorry?
I only found it.
Okay, do you know when it was put there?
No.
I have no,
I have no further questions.
You're excused now.
she may be excused now. Your Honor, I'll call Anna Lake if she's here. If she's not, I'm prepared to rest on what I have now. Your Honor, I apologize for the delay. I don't think the witness has arrived yet. My investigator is not out front. He may be on the phone trying to